to the legal landscape. On January 28, 2022, the Supreme Court struck down rules governing advertising in the legal profession. This ruling followed some very public issues between the General Legal Counsel and Bignall Law attorneys at law. The court ruled that some of the advertising restrictions placed on attorneys breached their constitutional rights, while other rules were upheld and permitted to remain. So, what was the effect of the court's ruling? Can attorneys in Jamaica seek new business by openly advertising on media channels, like we often see on American television? And did the rules imposed by the General Legal Counsel violate their constitutional rights? To help us address these questions, we are joined by Samantha Grant, who is an associate attorney at law at DunnCox. Thank you so much for joining us, Samantha, and welcome to The Edge.
Thank you so much for having me, Deon.
Well, Samantha, we need to ask you right off the bat, why is this case important?
Well, first, to give some context for the case, the rules governing advertising are called Canons, and they are found in the Legal Profession Act. The General Legal Counsel, or the GLC, is responsible for enforcing these rules. Now, Deon, to answer your question, these rules have been in place since 1978, and this is the first time the Supreme Court has declared that some of these rules are unconstitutional. So in short, this case is a big deal. And to be specific, the court has now recognized that some advertising restrictions imposed on attorneys have been violating our constitutional rights for some time without adequate justification. So big steps, big deal.
You called them canons, Samantha. Which canons were found unconstitutional?
Well, to be very clear, the canons that were struck down were not the ones governing the actual advertisements. Rather, the canons governing how the GLC responds to a breach of these rules were struck down. So essentially, due process was the issue. For example, one of the canons found to be unconstitutional was Canon 2H, which allowed the GLC to direct the alteration or removal of an advertisement without adequate due process. So the judge stated that the restriction was unnecessary and was not demonstrably justified as a limitation on the constitutional rights of attorneys. They were unnecessary since they could not on their own ensure compliance with the advertising standards. Rather, the GLC admitted that these rules relied heavily on the moral persuasion of attorneys to comply, which really means these rules work because attorneys feel obligated to follow them. Now, since they were found unnecessary to ensure compliance, these rules went too far in restricting the right to freedom of expression and the right to disseminate information through any media. So these constitutional rights are core, which cannot be easily limited without justification.
You're listening to Samantha Grant, Associate Attorney at Law at DunnCox. Samantha, can you share for us what is the effect of the court decision on the said canons?
Well, they were struck down, so which means they were null and void and of no legal effect. So attorneys are not bound or are no longer bound by these canons.
Mm-hmm. You see, when you say it like that, no people like me without the experience and the learning of going through all of this speak, we hear that loud and clear. But why are there restrictions on advertising in the first place, Samantha?
Well, the simple answer is that attorneys provide very special services. And what I mean by that is that we're first officers of the court and this places us in a distinct category that differs us from other service providers. So the conduct of attorneys impacts the public perception of the legal profession and the wider system of justice administration. This is the reason why lawyers are required to dress a certain way for the courts and are required to address judges and their colleagues respectfully and to conduct ourselves in and out of court in a particular manner. So given the importance of the role we attorneys play, some restraint can be expected in respect of our advertising legal services as opposed to advertising, for example, in the entertainment or gaming industries.
So are the rules in Jamaica considered to be very strict then? I know that the rules in the US, for example, appear to be a bit more relaxed.
Well, let me first say that we have come a long way. There are stricter rules in some states in the US, and there are more relaxed rules in other states. However, the rules governing legal advertising in Jamaica are far more liberal than those in some other Commonwealth countries. To give our listeners some background, up to 1998, attorneys were completely banned from advertising in Jamaica. That strict approach still obtains in many other Commonwealth countries. For example, the Legal Profession Act in Trinidad and Tobago is one example of a neighboring country that still follows that stricter model. However, for us here in Jamaica, the GLC removed the absolute bar on advertising in 1998, and the rules were further amended in 2016 to reflect a more relaxed, far more relaxed approach to advertising locally. So what the court has done is further the effort to strike a balance between allowing attorneys to exercise their freedoms, their rights, and protecting the integrity of the legal profession.
All right, so now that we know the jargon, I can ask you this question, and I'm sure everyone listening will understand as well. What advertising canons remain?
Well, recall that the actual limitation on advertising by attorneys have not been struck down. So we are still bound by those rules. For example, attorneys can advertise, but we are prohibited from publishing any false or misleading ads or any vulgar or sensational ads when doing so. So take it like this. I'm new to DunnCox, and I'm sure that we would love to say that we have the best litigators, the most prestigious conveyancers, or the most meticulous commercial lawyers. But the rules will not allow us to say that, of course.
You can say what you do.
Definitely.
But you can't say that you're the best. I got you. But what does this mean for attorneys now then, Samantha?
Well, this decision does not make it a free-for-all. The court struck down what were some of the enforcement options, but other enforcement options still remain, which includes fines, reprimands, suspension, or striking off if the action by the attorney amounts to professional misconduct. So we are still limited as to what we can release and how we portray ourselves to the public. The court did recognize that this is important to keep the integrity of the profession, so it's now left to the GLC to determine their response to the judgment of the court.
Okay. Well, thank you so very much. I mean, very clear, and congratulations to the profession. I'm sure for other lawyers stepping in to this new look, new feel, they're going to enjoy the little freedom that you have been given.
Definitely.
Can you share with us any hashtags did you know before you go?
Oh, definitely. So your listeners may be aware or may be familiar with the personal injury advertisements on American TV that usually goes to the tune of have you or a loved one experienced serious side effects after taking tablet X? If so, you may be entitled to serious compensation. Secure your compensation with the #1 personal injury lawyer. Call John Doe today. But Deon, did you know that those advertisements are unlawful in Jamaica? They would definitely breach these rules as they are now.
Okay. Well, thank you so very much for sharing with us and for keeping us up to speed. We look forward to having you join us next week as well. It's always interesting hearing the legal landscape right here on The Edge. Thank you for joining us.
Thank you for having me.
It has indeed been our pleasure. Samantha Grant, Associate Attorney at Law at DunnCox. Join us next week for another The Legal Landscape.